Hi, good morning, everyone. Welcome to our monthly compliance seminar. I'm Ann Lavelle. I'm the compliance specialist for CTR. And probably most of you on this webinar have heard me talk before. But if you haven't, just to give you a little background on myself, I was a labor and employment partner attorney at a really large firm downtown for a couple of decades. And then I came to my senses. No. I decided I wanted to spend more time with my family. So I retired, and I had been fortunate enough. I knew CTR from my prior life doing that. Retired from that. One of the things I always enjoyed was the educational component of what I did. And so this is a perfect little fit for me. I really enjoy presenting these monthly webinars. As some of you may have noticed, originally this webinar was supposed to be on the difference between sort of direct discrimination and disparate impact treatment or discrimination. But the federal government has gifted us with some new regulations. And so we pivoted with this so that we could bring you some timely information. And we're going to discuss the Federal Trade Commission today, what they have done, the Department of Labor, what they have done with the raise in the salary basis test, which is probably of greatest interest to everybody here. And if time allows, we will do the disparate impact mini version of that webinar. I always invite questions at any time, so please feel free to put those in the Q&A or chat, and I will get to all of them. I always stay late after the webinar, if I can put it that way, if there are additional questions that I can't get to during the webinar. But it makes it such a better learning experience if you ask your questions, because I guarantee if you're sitting there with a question, somebody else is as well. All right, we're going to dive in. And this is our outline for today, just so you can see it in case you want to come back. Everything we talk about today, including the slide deck, will be on the CTR platform web. So you can re-listen to it if you want, or look at it, or do whatever. It does take us a little bit of time to get it on the platform. It's not instantaneous, but it'll be there shortly. So again, this is recorded for today. All the slides will come to you. We send out an email. You'll have everything that we go over today. So if you miss something, it will definitely be there. All right. If you take nothing else away from today, these are the two things that we're really looking at. And this is it in a nutshell. The FTC has banned non-competes, past, present, future, with a few exceptions. And what most of you are probably interested in, and I have no idea why I have a little graphic here with happy smiling people, because most of you HR folks are probably not happy smiling people with all these changes. It's an increase in the salary basis. The government has decided to phase it in rather than making it happen all at once. And you can see the numbers there. The first phase is July 1st. The second phase is January 1st. And then every 3 years after that. We're going to do a deep dive on both of these, but if you want to know what today is about, this is it in a nutshell. Okay, let's start with the Federal Trade Commission first, because that's probably the easier of the two to handle for many folks. Why now? Why is the Federal Trade Commission, the FTC, getting involved with non-competes? Where did they get this idea from? First of all, if you are familiar with non-competes, the courts out there have had a growing reluctance to enforce such non-competes. And why is that? Well, they're frequently misused by employers. Employers have the most bargaining power, right? I want a job, so I'm likely to sign anything you put in front of me. And when I'm hired, even though 2 years from now I'm going to regret it. Uneven bargaining power, onerous agreements that really are not limited in terms of the scope, the geographic scope, or the time. You know, if you tell Ann Lavelle you can't work in your chosen profession for the next 10 years across the entire world, all of a sudden I have no job, really. And that's an exaggeration, but a lot of them really were inappropriate. The example that I've used over and over is we were involved in a case one time that involved hairstylists. And I do understand that you don't want them to take all of their clients with them. But these are not high wage earners. And if you tell them they can't work anywhere in Pennsylvania, Ohio, or West Virginia, um, after they leave your styling salon, that's a really onerous obligation to put on their shoulders for a relatively low paying profession. They're not going to steal your trade secrets. They're just, a small client list. Amen. Many states have already imposed limitations on non-competes. Pennsylvania is not one of them. But other states, particularly out west, have been either prohibiting these outright, like California, or limiting them to employees who earn a certain amount. They're trying to say, hey, only the highest level of professionals, the ones that are paid the most, should be subject to these non-competes. And usually that salary threshold was over $100,000 for to have an enforceable non-compete. In this day and age with remote workers, remember, it's where the worker is, not necessarily where your headquarters is, that might control whether a non-compete is valid and enforceable. So that's why the FTC stepped in, is we have a patchwork of state laws that have different perspectives on non-competes, and a patchwork of court case law that is unfavorable to non-competes as well, but is all over the board depending on what state you're in. The FTC, and this is really important because we'll talk about this in a minute, they believe they have the authority to regulate this because non-competes and employment and employees affect commerce in general, right? We have no commerce if we have no employees. Statistically, we know that about 1 in 5 American workers has some type of non-compete. The FTC believes, and this is subject to debate, but they believe that their proposed prohibition on non-competes would increase American workers' income somewhere between 250 and 296 billion a year. Again, that's their estimate, but it undoubtedly will make it easier for workers to go from one job to another. All right, so what has the FTC done? So in a nutshell, they have prohibited all non-competes. A non-compete, just in case anybody doesn't know, says, I, Ann Lavelle, if I leave CTR, cannot go and be a compliance officer to any other similar company within some sort of limited geographic area for the next year or two. In any event, the only non-competes that are permissible, according to the FTC, is if there's a sale of the business. So if I own the business, and this kind of makes sense, right? If I have a successful business and I have sold it, and as part of that sale, the new owner wants a non-compete because they don't want Ann Lavelle to go set up shop right next door and open up the same business and take all their clients, that kind of makes sense. So if I sell a business, you can still have a non-compete. If there's a current non-compete with what's called a senior executive who earns more than $151,164 and makes policy decisions, you can keep that non-compete. You can't have a new one in the future for somebody like this, but you can keep the one that you currently have with this person. Why the 151,000 and some change? You'll see the same number pop up when we talk about the FLSA. They're trying to align their regulations for anybody who's highly compensated. This rule does not apply to nonprofits because nonprofits in general are beyond the scope of the FTC's authority. So it's not as common to have a non-compete in a nonprofit. How many, churches or synagogues or whatever do you know that have a non-compete with their pastor or rabbi or whoever saying, hey, you can't go to another church? That's really not that common, but you could have it in some other nonprofits for their higher level employees. This applies to any affected worker, which means both employee and independent contractor. So that's an important distinction there. When this goes into effect, and we'll talk about when it goes into effect, or if it will go into effect, it requires the employer to provide clear notice to individuals who currently have a non-compete, so both independent contractors and employees, that it's no longer valid. One of the key things that came out of the FTC regulations that they announced was that this applies to any agreement, and that's key, any agreement, whether labeled as a non-compete or not, which has the potential to chill the ability of a worker to change jobs. This concept of any agreement that could chill a worker's ability to move from job to job is not well defined. It certainly is going to apply to what I would call anti-poaching agreements. So if you attended our live and in-person seminar a few weeks ago, this topic was brought up. And someone asked, well, what if we have employees from a vendor in our work site and we have signed an anti-poaching agreement that we won't hire their people away? Would this be covered? And at the time, nobody knew. We now know it will be. So something like an anti-poaching agreement, even though it's not labeled as a non-compete, is going to be covered by this law and is going to be prohibited unless we're talking about nonprofits. If you had a non-disclosure agreement, and this is one of the examples the FTC used, that was too broad, or a non-solicitation that's too broad, that essentially meant I'm not allowed to solicit any client CTR has ever had anywhere in the country. That might be too broad. That might limit my ability to change jobs, and that might run afoul of this law. We don't know. But we need to know, we know now though, we're not going to be able to have anti-poaching. We're not going to be able to have non-competes. And we need to make sure our NDAs, our non-disclosure agreements, and our non-solicitations are narrowly tailored that it won't keep me out of the workforce if I leave you. There's also a lot of unknowns. So sometimes you get very sophisticated deferred compensation arrangements or severance agreements with deferred comp that require me not to compete for a certain amount of time. Nobody knows how this rule will apply to that. This rule is effective 120 days after publication in what's known as the Federal Register. It was just published. So the effective date will be September 4th. But there's already court challenges. Anytime the federal government does anything, either party, whatever, the other party is challenging it. And I stay apolitical. I'm just saying there's always a legal challenge. So can this withstand a court challenge? A lot of people don't think so. So this may be a lot of hoo-ha for nothing. You may be saying, great, we just wasted the last 10 minutes. I really want to hear about the FLSA, and she's babbling about non-competes. I think this is important though, even if this does not withstand a court challenge, and the reason people think it won't withstand a court challenge is because traditionally the FTC has never been involved in any type of employee issue. They've never tried to regulate an employment relationship. It's a major issue. It's questionable whether they have authority to do that under their enabling statute from Congress. It's really, and we have a very conservative Supreme Court that seems to be taking a dim view of regulatory agencies and their authority to begin with. So really questionable whether this will actually pass muster and be the law or be the regulations by the time it gets to the Supreme Court, which it likely will. At a minimum, it probably won't take effect on September 4th because no court challenge moves that quickly. Why do I think we should still pay attention to this? So the FTC is trying to do what Congress hasn't been able to achieve, which is sort of outlaw non-competes. But the courts are out there doing it anyway. The courts don't favor these to begin with. In most jurisdictions, they're extremely expensive to litigate for both sides, employers and employees. And oftentimes it's just not worth it. So whether this holds or not as the regulations, or whether it gets overturned, my thoughts to all the employers out there that might have non-competes or anti-poaching or anything like that is you maybe want to reconsider your strategy on some of this and make sure those are really narrowly tailored and focus more on your non-solicitation, NDAs, things like that, to try to secure your intellectual property, customer lists, whatever it is that you want to secure, because these agreements are under fire from the courts, from the regulatory agencies, and from the state legislatures for sure. Okay. Again, if you have any questions, just feel free to put them in the chat box there. So, all right, let's move to the topic that probably everybody wants to talk about, or maybe we don't want to talk about, but we have to. And that is, what is going on with the Fair Labor Standards Act, and does it apply to us? So the answer is it's going to apply to just about everybody, because employers are going to find themselves with employees in this category. So briefly, and we've done a number of webinars on what it takes to be exempt, because that's a subject of a lot of litigation. Those webinars are all recorded. But essentially, an employee to be exempt, which means they will not receive overtime pay for more than 40 hours in a week, or in some states, it's more than 8 hours in a day, or whatever it might be. Pennsylvania does not have any daily overtime laws. The employee must meet both the duties and what's known as the salary basis or salary level test for the particular exemption. So the most common exemptions are what's known as the executive, administrative, and professional exemptions. And people get these wrong all the time. It's very complex and not clear under the regulations, and it gets confusing. But somebody like the executive exemption, they have to manage at least 2 or more full-time employees. They have to have sufficient discretion and judgment in their daily work, which that's always a subject of a question mark, because what is sufficient discretion and judgment? And they must be paid a salary that meets a certain level or certain basis that does not vary based on the quantity or quality of the work performed. So even as we sit here today without the new regulations, if you don't pay a salary of at least $684 a week, and you can pay it, however you want to pay it, like bi-weekly or whatever, they're not going to be exempt. So somebody put up here a question about teachers. Teachers are a little bit different. Teachers can be paid under the FLSA on a day per diem, although in Pennsylvania it's questionable whether that's legal. Private teachers, I disagree. Private teachers are definitely subject to this, particularly in Pennsylvania, which doesn't really recognize the per diem rate for teachers. But thank you for the comment about whether teachers are subject to the FLSA. So teachers are a little bit of an outlier, but they definitely, for a private school, would fall under the FLSA. So in any event, somebody also has asked, what about nonprofits under 50 employees? Absolutely, 100%, you are covered by the FLSA. Does not matter that you're a nonprofit. Doesn't matter the number of employees you have. So great question there, just to lay the groundwork for everybody. The FLSA applies to almost all employers, regardless of size, regardless of the number of employees, and regardless of whether you're a for-profit or nonprofit employer. In any event, so right now, as we sit here today, regardless of what the Department of Labor thinks it's doing or what it doesn't think it's doing in the future, we know that right now, somebody to be exempt and not get paid overtime must have a salary of $684 a week. That's not changing. It's only going to go up. So if you're sitting here right now and saying, well, gosh, I have folks who are not $684 a week, they're automatically not exempt. This new law doesn't change that. It just means you're not in compliance right now with the law. You also have to meet the duties test. So just paying the salary. If you're sitting there saying, well, I pay $684, I'm all good, that doesn't necessarily mean you're out of the woods either, because you have to meet the duties test, which is usually the more difficult of the two tests to determine whether or not you have met it. What we see now with the new regulations is it's going up, right? So July 1st, and the government feels that they're providing employers with an opportunity here, because originally the entire amount was supposed to go up all at once. And they're saying, no, based on the comments we got back, we're going to phase in this increase in the salary basis. It's going to go to $844 on July 1st. So anybody who earns less than that on July 1st is automatically non-exempt and is owed overtime if they work more than 40 hours in a week. And on January 1st, it's going to go up to $1,128 a week. Let me just take a look here at the questions we got. We got several rolling in. Okay, what if my employees earn more than 50% of his pay versus commission? Okay, we'll talk about commissions and stuff in a second and how that can be applied. How should office managers in a K-12 district or K-12 school be treated? So office manager, that's a tough one because a lot of people try to say, well, maybe they're executive or maybe they're administrative. We've covered the duties in a lot of past webinars, but oftentimes what I'll call a lower level supervisor, office managers often are, they're not going to meet the duties test because they often don't have enough discretion and authority to meet the duties test. It's a very fact-intensive inquiry to know whether or not that office manager, like any first level supervisor, is going to meet the duties test here. Okay. We are getting a ton of questions and that's good. Let's see. Okay, so somebody else asked, and this is, again, going more to the duties test than the salary test, but let's touch on it for a moment because it shows the importance of the duties issue here. The question is, they operate a startup software company, and startups are always tough because, you know, you're often on a shoestring and you're trying to make everything work. They have an entry-level staff that they're categorizing as data analyst, data entry. They do not manage individuals. They're currently exempt salary. Does this apply to them? So my first thought on that would be, it's pretty clear under the regulations that anybody who is doing data entry is never going to be exempt under the duties test. So regardless of what you pay them, their duties are going to fail the duties test because data entry is a pretty rote or routine event. It doesn't take any discretion or judgment. Data analyst, we'd have to have a lot more information to know exactly what data analyst means. If that's the same thing as data entry, they're not exempt either. If you could increase their duties to give them more discretion and judgment, right? So it's the executive exemption where you have to manage 2 or more folks. The administrative exemption, you don't have to manage anyone, but you have to have sufficient independent discretion and judgment in what you do in order to be exempt. And so when we look at like the administrative exemption, simply entering data or following policies is insufficient to be exempt. And so even if you paid them $684 a week right now, they won't be exempt because they don't have sufficient independent discretion and judgment. If you are not paying them the $684, it doesn't matter about their discretion and judgment or anything else, because if you fail the salary basis test, which is a pretty black and white test, either you're paying it or you're not, you're out of the ballpark already. You will not have an exempt employee if you're not currently paying them $684 a week. Okay, I'll get back to the questions a little bit because we're getting so many of them, which is great. That'll be good learning opportunity here, but I hope that helps give a few examples of the duties tests. Again, we've done a webinar completely on the professional, administrative, and executive exemptions that talk about what the duties are that you need to have in order to try to make those exemptions work. All right. In addition to the weekly salary for the executive, administrative, and professional exemptions, the highly compensated folks, their threshold has gone up as well. So what is an HCE? An HCE is a potential exemption that you can use for somebody who earns a lot of money. Right now, they're at around 107,000, and it's jumping up to 151,000 by January 1st. Again, there's a step to it on July 1st, but that's where you'll end up, which coincidentally enough is the same amount as the non-compete threshold. In addition, these folks must also perform what I'll call office or non-manual work. It can't be somebody who's actually out in the field, digging or whatever. That's not how this exemption works. They have to have a relatively sedate job and be paid a lot of money, but they might not completely fall into the executive, administrative, or professional exemption. One of the things to keep in mind is that not all states recognize this exemption. Some states are more restrictive and don't necessarily recognize this as a potential exemption. Pennsylvania is a classic example of being different than the FLSA. Pennsylvania doesn't recognize, for instance, computer professional exemptions, which does not go to the gentleman's question about the data entry. There is a possibility under the FLSA in some states that you can pay computer professionals, which are generally programmers, a hourly amount. Pennsylvania doesn't recognize that at all. So if you do that in Pennsylvania, the person will automatically be non-exempt, even if they are exempt somewhere else. Okay, so somebody's asking if an HC makes less than the new salary threshold, does this mean they get overtime? Yes, absolutely. Thank you for the clarification and the question. Absolutely. So come July 1st, right? Not the 2nd, but July 1st, or any delay due to courts, and we'll talk about that in a second. If the HC, who otherwise is not doing manual work and has a pretty sedate job, come July 1st or January 1st, isn't making those thresholds of about 132 or 151,000, they will not be exempt and they will be owed overtime. So that's critical. If you have an HC, somebody who meets it right now, you need to look at what their salary provision will be in the future. Is the HC provision apply in Pennsylvania? That's a good question. That hasn't been tested here, but there's nothing in our statutes that recognizes it. So be very careful of the HC provision in Pennsylvania, because Pennsylvania likes to be quirky and not recognize everything that's in the FLSA. We don't recognize what's known as the 8 and 80 rule. For those of you in healthcare, you might recognize that. There's a number of things. So HC, be careful of that in Pennsylvania, because we do not have a direct correlation in our Pennsylvania wage and hour law that would recognize the HC. We haven't had a test case on this that I'm aware of either, but certainly if you want to try this in Pennsylvania, I would strongly recommend talking to counsel about the potential risks there and whether they think Pennsylvania would ultimately recognize this exception or not. If I was concerned in Pennsylvania, I would try to see if I couldn't fit the person into one of the other exceptions, which earning this much money, you might be able to, because they probably have a lot of discretion and judgment if they're earning over 6 figures, but not always. Okay, somebody else is asking, what about HR manager, fiscal manager, fiscal analyst, clinical director? So a lot of those depend on how much, they all depend, I should say, on how much discretion and judgment the person has. All of them right now, to be exempt, have to earn the 684. If they're going to remain exempt, going back to our little cheat sheet back here, they would have to reach the new salary thresholds come July and come January. But in addition, at all times, they have to meet the duties test. Without knowing more, it's almost impossible to know whether or not they have sufficient independent discretion and judgment, or manage enough people or anything else to know whether those 4 job titles, because job title is irrelevant in this analysis, whether they're going to have sufficient independent discretion and judgment. For instance, an HR manager could be the sole person in the company who does everything for HR. And some of you are sitting here going, yeah, I know what that is. And has to run the entire show, has all the independent discretion and judgment in their role, versus somebody who is an HR manager under the HR director, who's under the VP of HR. An HR manager really, it doesn't have any independent discretion and judgment. They can't go fire somebody. They basically help people fill out forms for enrollment and benefits or new hire forms. None of that's going to be independent discretion and judgment to satisfy the exempt duties test for any of the exemptions. So when we look at this, it's impossible to tell just based on a job title. There is no list of job titles that says, hey, fiscal manager, exempt, HR director, exempt, but HR manager not, or anything like that. You have to look at it on a job-by-job basis as to whether they have sufficient discretion and judgment. And the cases are all over there, all over the board, as to what's sufficient discretion and judgment. Let me see, we've got a bunch of questions here. Let me see if I can answer a few more here. Okay, I'm new to healthcare. What is the 80-20 rule? It's actually the 8 and 80. It's a way of paying people where you look at whether or not they earned overtime over 2 weeks. We don't recognize it in Pennsylvania. What if our main office where payroll is done is in Ohio, but we have a branch in PA with several workers? How does the different state laws affect the business? Fantastic question. So let's talk about that a second, even though it's not directly on the salary basis. So we look at where the employment takes place. So you essentially are under 2 different sets of laws, 3 if you count the federal system. So at a federal level, you have the FLSA, which right now we know all about the duties tests. We know we have to make at least 684. And we know that is going to go up. Under each state, you would look and say, what are Pennsylvania's quirks? What are Ohio's quirks for the folks who are in Ohio? Most of your employees, it sounds like, are in Ohio. But for the folks, you have a branch in PA with several workers. Those folks in Pennsylvania, and I'm not an expert in law in Ohio, are going to possibly be different than Ohio. They may be the same. Perhaps Ohio and Pennsylvania are going to align on the type of people you employ and how you're paying them, or they may not. You know, a better example would actually be California and Pennsylvania. California is had too much sun or something. I don't know. They are very different in their employment laws. So they have rules about daily overtime, whereas Pennsylvania does not, right? The federal law has nothing about daily overtime. It's over 40 in a week. But if you had an office in California, just to embellish this example and give more meat to the bones to show the difference, the folks in California at your branch in California would be subject to the daily overtime laws. The folks in Ohio would not be. The folks in Pennsylvania would not be, because neither state has daily overtime laws. We could go through a whole bunch of differences between California and Pennsylvania or Ohio because California is so unique. But what you're looking for is any differences in how the 2 states might treat something. For instance, Ohio might recognize the federal computer professional exemption. Pennsylvania does not. Ohio might recognize the 8 and 80 rule. Pennsylvania does not. So you're looking at the law where the employees are performing their work. It doesn't matter that your headquarters are in Ohio. For most of your employees, Ohio law is going to control because it sounds like most of them are over in Ohio. But for your branch in Pennsylvania and the workers that are primarily employed in Pennsylvania, Pennsylvania law will apply. I hope that answers that question. Okay. Let me, wow, we are getting some really intense and good questions. Let me move on because I want to make sure we get through all the FLSA slides. If we skip the disparate impact, I don't think anybody's going to cry. That's okay. Moving on, we have a question. Do physician assistants and nurse practitioners automatically meet the professional exemption? There is nothing in any law that says, hey, if you are this job, you automatically meet the exemption. That just is not part of the law. However, absent something really unusual that you're doing with them, they generally will. So when we look at the professional exemption, we're looking at folks who have independent discretion and judgment, but also have some type of advanced degree that's at least 4 years in the specialty in which they're working. So presuming that we have what I'll call a typical nurse practitioner who's not not like has decided to quit being a nurse practitioner and is now the receptionist, but she's actually doing what she's trained for, and she's treating patients, and she's deciding if Ann Lavelle walks in, Ann Lavelle has an ear infection and needs antibiotics, that's going to look exempt. Physician assistants, same thing. So assuming that they're doing what I would call traditional work and they have those advanced degrees, you still have to pay them the salary threshold, right? They still have to be right now 684 or more. They're going to be exempt. That would almost always be the case unless you're doing something really unusual with them, like that would nullify their independent discretion. Okay, what if you have a program that requires your employees to be on call 24/7, 365 days a year? So my first advice to you would be to reconsider that program. This goes beyond the scope of our seminar today, our webinar, but just to touch on it briefly, whether or not you have to compensate somebody for being on call depends whether how restrictive you are on what they can do while they're on call. So if you have a non-exempt person, somebody gets overtime, you may actually owe them for those hours of being on call, even if they do nothing, if you're very restrictive on where they can go and what they can do while they're on call. For somebody who is exempt, being on call, it would depend what their real job is. If they're a doctor and they're on call, that's probably still exempt, right? But it would depend for somebody who's exempt what they're doing. Being on call often leads to a lot of overtime issues and litigation because employees resent it if it's too restrictive. And you get issues as to, well, I wasn't allowed to leave Allegheny County when I'm on call. I had to wear my phone the entire time and have it on. And therefore, I really was on the job, even though I wasn't doing anything other than listening for my phone and should be paid for all those hours. So if you have on-call policies, really run that past legal counsel because those are extremely concerning as to what you're doing. Again, if you had somebody like a doctor, that would fly, but a lot of other positions it won't. So be very careful of those. Okay, so somebody asked about the link for the PA teachers. We're talking not colleges. Just to the person I think is referring to a college. That we're talking about high school teachers here that we don't necessarily recognize the daily exemption for them. Professors would be a different category altogether. Okay, let's go back to our slides here. Okay, so somebody had asked this the other week and I didn't know the answer to it during another webinar. They said, hey, are we still going to be able to make up a portion of the salary basis test through incentive comp, essentially? So non-discretionary bonuses, commissions, anything along that line. Make sure it's non-discretionary though. And we did a whole webinar on non-discretionary versus discretionary. So you have to make sure what you're doing is falls into the non-discretionary category, that you must pay the bonus if certain metrics are made. Incentive payments, the commissions, to answer your question, somebody else asked about commissions. Note that it can only be 10% of the total comp though. So if we're trying to make somebody exempt and we want to use commissions for like the professional, administrative, or executive exemptions, we have to say, oh, we can only use up to 10% of that number. The 684 right now, and of course it's going up to 1,128. Only 10% of that can be made up through commissions if we want them to be exempt. If we don't want them to be exempt, we just pay overtime. When you use this, you do have a year-end reckoning, so to speak, where by the first pay period, if the person hasn't made the goals here, you can do a catch-up payment. But again, that person has to make at least 90% of the 684 right now on a weekly basis. So they can't be earning less than the 90%. Okay, DOL estimates that this rule will essentially transfer 1.2 billion from employers to employees in the first year, predominantly in new overtime payments, or by raising the status of folks who maybe don't quite earn enough. Maybe you're going to bump up their salary to make sure that they are exempt. The DOL also feels, and this is their opinion, that these wage transfers will reduce the risk of misclassification, which is one of the leading causes of lawsuits under the FLSA. The data entry example that somebody asked about is a perfect one. That's a misclassification because data entry is almost never considered exempt work. It may increase worker productivity and reduce turnover, and maybe it gives more personal time for those who no longer have to work uncompensated overtime. Okay. So where are we at right at the moment with this? Are we actually going to have to deal with this? So we already have court challenges to this. We probably will not hit the July 1st or the January 1st deadline, given the way the courts move. They just don't move that fast. This is almost certainly headed to the Supreme Court. What is very interesting about the Supreme Court is right now they are very conservative, right? And one of the justices in another FLSA case essentially invited this lawsuit and said, Justice Kavanaugh just said, he doesn't think the DOL has any legal basis to issue a salary basis test, and that most of the DOL regulations are invalid. So that's quite a statement from a justice who hasn't even heard this case yet. I cannot not imagine that this won't hit the Supreme Court, and we'll see what happens. The other thing, we're in an election year, right? So the last time we had this scenario where we went from Obama to Trump, there was litigation over an FLSA increase, and Trump chose not to pursue it. So it just died. That increase never went into effect. Whether we get the same outcome here, if we go Biden to Trump, does Trump drop this and say, hey, never mind, I don't want to pursue this? Who knows? But we need to keep both the courts and the election year factor in place, that are in play, and think about how they impact things. That doesn't mean that we shouldn't prepare for this, because even if we don't hit the 1,128, we might hit a lower metric, because I think everybody is saying this needs to be increased somewhat. So look at your employees now. Look at the three buckets you have. Clearly non-exempt. They're non-exempt right now. They're under $684, or they don't meet the duties test. Nothing will change. You can't raise their salary to somehow miraculously make them exempt if they're not meeting the duties test. And if they're under $684 a week, they're non-exempt right now to begin with. Then you have the clearly exempt folks, right? The ones who are over 684 or over the 107,000 if you're in a state that recognizes the HC exemption. And you know, if they're over the 1,128, they're clearly going to be exempt as well in the future. And maybe don't worry about them. It's the folks that fall in the middle there that are exempt right now because the duties test is met, but they're only at the 684 or a little above it, and you have to decide what to do with them. And really, your choices are limited, right? You're either going to say, okay, now the person is non-exempt whenever this rule actually takes effect, which is unlikely to be July 1st, but you don't know. And I'm going to pay overtime to them. I'm just going to accept that that's the case. I can raise the salary, right? I can bump them up into the 800s and then into the 1000s, knowing that every 3 years under this new rule, these metrics are going to increase. I can hire more employees, so I don't have to pay overtime, but the cost of benefits may be a detriment there. I can restrict working overtime, right? I can tell Ann, hey, don't work overtime. You'll be disciplined if you do it. If I actually work overtime, you have to pay me, but you can discipline me for that. And then you have to hope that the work gets done in 40 hours. If you're in a state that's just the 40-hour rule. But you need a contingency plan in place. Whatever you're going to do, you're looking at that subset of employees that's somewhere between the 684 and the 1,128 that meets the duties test already, What do you do with them? And that's the bucket that you're looking at, and you're saying, I'm either going to raise the salary, I'm going to hire more, I'm going to freeze overtime, whatever it may be. That's your contingency plan. Because when the courts make the decisions, if you've been through this drill before under the FLSA, you have almost no time to implement the plan. It's too late to sit there and say, I'm going to wait till the Supreme Court decides what they're doing, because once the Supreme Court decides it, it takes effect relatively quickly. You're lucky if you have 30 days to implement it. So you need to know what you're going to do in that situation. Let me go back to a couple of questions here if I can. All right. Okay, so somebody asked, and this is a good question, is there a website that would show duties tests related to a specific industry? For example, in this individual's question, auto dealerships. No, there's not. So what we have, and it's really a hodgepodge of things that are out there, is if you go to a law firm and you say, I want an FLSA exemption review, and my firm used to do it, lots of firms will do it. They take the job descriptions for each employee, and some are very obvious, right? So somebody who is just a car lot attendant, they're never going to be exempt. There's no independent discretion and judgment involved in where they're bringing a car to. But you look at case law, there's nothing from the Department of Labor, which I think is kind of unfortunate, that says, hey, all auto detailers are exempt, or all whatever profession or job you want to pick are going to be exempt. You look at court cases. So when we got this request, when back in my prior life, we would look at the job descriptions. We'd talk to the employer to make sure that the job descriptions actually reflected the duties performed and how much of their time, because a sufficient amount of their time should be spent on the duties that involve independent discretion and judgment. It's not enough that they just make one decision a month. That's never going to cut it. It should be all the time, basically. And so we look at that, and then we look at case law to say, what have the courts said about auto detailers or whatever job we want to pick? And where do they come out? Is there a case in Pennsylvania, because obviously that's where I practiced, that would say auto detailers are or are not exempt? And then the really fun issue that we would run into, and which drove clients nuts because attorneys are famous for this, is it depends, right? So the best example I have of this is insurance adjusters. In some states, they are considered exempt, because if I hit my car, right, I have an accident, and I take my car in, they look at my car and they say, okay, it's whatever year, whatever model type, I ruined the bumper, here's what it is. Some courts say that's independent discretion and judgment, and others say no, it's not, because really the insurance adjuster is just looking at a manual, and they know if I bring in a Honda Civic that is X years old and I need a new bumper, it's X number of dollars. There's no independent discretion and judgment. I'm just looking at a manual. And so what you end up with is a hodgepodge of decisions across the country of, in some states, the insurance adjuster will be exempt, and in some states they won't, depending on where the courts have come down. There's also what we call DOL opinion letters, and the opinion letters are limited in enforcement or effect to the company that's asked for the opinion. And unless you're really large, you don't want to go after an opinion letter, because these take a year or two to issue sometimes. It's expensive to do. Sometimes the DOL won't give an opinion, whatever. We also look at those. There's a bank of opinion letters. The problem with those is they vary depending on which administration is in office at the time the DOL opinion letter is issued. There's different thoughts within the DOL depending on whether we have a Republican or Democratic president in place. But they can give some guidance as to whether or not a particular job will be exempt. So to answer your question in a very long-winded way, no, there is nothing out there that the FLSA has published or anybody else has published that say, hey, all auto detailers, all lot attendants, all salesmen, all this, all that are exempt, because it's different places have different job duties for each job and maybe the same job title, but different duties within that. So unfortunately, there is nothing you can go look at. Let me go down here a few more. Okay, so somebody's asking a really good question here. So under the FLSA, believe it or not, there are specific rules for amusement parks and recreation establishments that operate less than half a year, basically. And you don't have to pay overtime in some cases and stuff like that. I have not looked at this under Pennsylvania law ever. I do not remember Pennsylvania having a mirror exemption that applies to amusement parks or recreation facilities or anything like that. So while that is available under the federal law, I can't give you an answer off the top of my head about the state, other than to say I don't recall either seeing litigation on this or seeing in the statute the mirror state exemption for amusement park folks. That would be something that I would advise you to talk to counsel about to see whether they think Pennsylvania would recognize the FLSA exception or not for amusement park facilities that are only open for a limited amount of time or generate most of their revenue in a limited amount of time if you're in the state of Pennsylvania. So very great question. That's a very nuanced question about a specific industry. Okay. All right, somebody is saying, hey, it sounds like I might have a boo-boo. That's a highly technical legal term, but it happens all the time. And I might have folks that I need to change to non-exempt. Do I need to have a formal time clock system? So let me answer that in two ways. First of all, the FLSA, as well as Pennsylvania state law, requires that you keep a record of the hours worked somehow. It does not say you need a punch clock as they had in the old days. You could do it on a computer, right? You could do it on pen and paper. It doesn't matter. Obviously, CTR sells products that keep time, but there is, from a legal perspective, there's no, you must use a punch clock or you must use a computer system or whatever. It just has to be an accurate record of the person's time. What I would caution you about is a couple of things. First, when you're keeping the record, it's always best for the employee to make the record because then it's in their handwriting, so to speak, and you haven't, as an employer, assumed that they got a lunch or something because maybe they work through lunch. Second is if you think you have a mistake, right, and you're going to switch everybody from exempt to non-exempt or a subset of folks, you need to be thoughtful of how that's going to be received and whether that raises red flags to anybody who says, wow, I've been working here 2 years and all this time I should have had overtime. And their recollection, which it always seems to be the employee's recollection, that they've worked at least 100 hours a week, every week, including Christmas, New Year's, and Easter, and you never paid them. And that opens you to a lawsuit. So you have to be very thoughtful. If you think you've made an error in classification and you have folks that are non-exempt that you've not paid overtime to, you want to look at your exposure and say, do I think any of these folks ever worked more than 40 hours a week if we're in Pennsylvania? Do I think I have exposure there? If so, can I quantify that? Do I have a rough estimate in my own mind, even if they exaggerate the claim? Do I have a feel for my exposure here? And how do I roll this out in a way that doesn't highlight the error and maybe has a spin on it that says, hey, we're moving in a way that will actually give you more income. Okay. Okay, if you have a salaried employee that will not meet the new threshold, but currently considered exempt, and you change them to hourly instead of increasing the salary, are we subject to guarantee them 40-hour work week? No, you are never required to guarantee somebody a certain number of hours unless there's a union contract or an employment agreement to the contrary. But assuming I'm just an at-will employee and I'm not a union member or something quirky that would affect this, you don't have to guarantee them anything. And then the question goes on to ask, and this is a great follow-up here, how is it handled if they have to leave early or come in late? So it's handled there's two different issues here. One is a cultural issue about discipline, and the second is a pay issue. So from the pay issue, it's pretty clear. If normally I'm supposed to come in around 8, and because I had a doctor's appointment or I wanted to go see my little kid's kindergarten program or whatever it is, I come in at 10. As a non-exempt employee, I don't clock in until 10 o'clock, right? You got to keep track of my hours. And then I leave at 5 as normal. And so you just pay me for those hours minus a lunch break if I've had it between 10 and 5. You don't pay me for the hours that I wasn't there. Same thing if I left early. Now, the second issue, though, is a cultural issue, right? The question is, oftentimes with exempt folks, there's a lot of flexibility. Not always, but usually. So an exempt person might be used to the fact that, hey, if I take the morning off to go see my kid's kindergarten performance and I come in the afternoon, nothing happens to me. I'm not disciplined because the assumption is I'm a professional, and I don't mean the professional exemption. I just mean I'm a professional in general, and I'll make up my time, or I may have worked all Saturday for you guys because we were really busy. And so taking off 2 hours Wednesday morning didn't seem like a big deal. It's a cultural issue when you have somebody who does that, whether they're exempt or non-exempt, whether you discipline. You need to be consistent in whatever your decision is with respect to discipline so that everybody in the same situation, similarly situated employees, is treated the same. But you need to think about that and say, well, gosh, for this job, are we going to be upset if somebody does that? And of course, I might have PTO that might make up for the time, I might not. But there's a bunch of factors that we can look at culturally and say, well, if they have PTO, we're not going to discipline. If they're out of PTO, maybe we will, unless it falls into a mandatory leave that we have to give them, like the city of Pittsburgh sick leave or FMLA or something like that. So that question, again, long-winded answer, but a great question because there's a lot of things to think about there. Okay. So somebody's asking about a specific Pennsylvania law under Governor Wolf, where if I'm thinking of the right act here, where we were going to raise in Pennsylvania certain wages and salary levels, and then we backtracked off of that because to get the budget done in Pennsylvania, the Governor Wolf decided they would not raise these levels to get a budget deal. Basically, I'm really oversimplifying that. So how does that impact this? It doesn't impact it at all. Federal law always trumps to the extent it provides better benefits to employees. State law would only trump if it provided better benefits to employees. That's why in this situation, the Pennsylvania law is about increasing the salary and wages that went out the door because of the budget issues. When would be trumped by this at this point, this law would stand. But when we look at something like the 8 and 80 law that Pennsylvania doesn't recognize, state law is more restrictive there and better for employees. So that's why state law would trump. So generally speaking, federal law trumps state law unless the state provides better perks or benefits or whatever you want to call it to employees. Okay. Somebody is well-versed in Pennsylvania law, which is a good thing there. All right, we're going to keep going. I'm going to answer a few more questions, and we'll probably hold the disparate impact until next time. I hope nobody is super disappointed about that. And we'll just finish up with questions here. So I have a salaried employees whose positions, and by the way, if you have to go, totally understand that. I don't want to impinge on anybody's time. We'll hit disparate impact next time. But thank you for attending. If you have to drop off, I understand all these questions will also be recorded. So if you have to go to lunch or whatever, you can listen to this later if you want, but I will stay here and try to answer as many questions as I can. Okay, I have a salaried employees whose positions may require them to work 60 hours this week, but next week they only work 20 hours based on the program needs. So that's irrelevant to whether or not they're exempt. From a cultural standpoint, and this kind of goes to the previous person's question about what if they come in late or something, what if I worked all day Saturday and want to take Friday off? It does not affect whether they're exempt or non-exempt. That's a cultural issue of whether you say, well, since you worked 60 hours this week, we're only going to make you work 20 hours next week. It does not change whether they're exempt or non-exempt. We still look at, did we pay them the right salary and do they meet the duties test? If they fail on those, it does not matter that the time averages out to only 40 a week. That has nothing to do with anything. We never look at averages under the FLSA. We look at hours worked in a work week. And so if these folks are non-exempt, right, if we decide, gosh, either because we don't pay them enough, they don't meet the salary basis test, or they don't meet the duties test, in the week that they work 60 hours, they're going to have 20 hours of overtime, assuming we're in Pennsylvania. If you're in a state that pays daily overtime, it would be even more. Next week, they get paid for 20 hours. We don't get the benefit of averaging that out somehow. All right. Okay, are lunch breaks required for non-exempt employees? I'm having trouble making people take them. So if we're in Pennsylvania there, and we're talking about adults over 18, you're not required to take a lunch break. You can make people work through lunch. They can voluntarily work through lunch. No break is ever required. Now, I think that's a poor cultural thing. I think that's a poor health decision for employees if they're making that decision for themselves. But there's no law in Pennsylvania that requires it. In some states, there are. So what we have here is we've got a situation where with the lunch break, they'd work 8 hours. Without a lunch break, they work 8.5, which I assume is triggering overtime at the end of the week. So typical 40-hour week, if I have a half hour every day that I've worked through my lunch, if I'm doing the math correctly, and math is not necessarily my strong suit here, we have 2.5 hours of overtime. We have to pay them for working through the lunch break, even if we said don't do it. We know they did it. They worked through lunch. We're going to pay them the 2.5 hours of overtime. At that point, it becomes a cultural decision where we say, gosh, maybe we don't want to pay the overtime, right? It's not worth it to us if these folks are non-exempt, right? And we say, it's going to be a discipline issue. You either stop working through lunch or you get disciplined. That's a little bit of a harsh result because maybe that person is really trying to get the job done, but it's our call as employers to make. If these folks are exempt, based on the duties and the salary basis test, we don't owe them anything. So they can work through their lunch, they can work through their dinner, they can work till 2 a.m. It does not matter. We don't owe them overtime, assuming that they have met the duties test and the salary basis test. So when you look at this issue, and it's a great question, we're looking at whether they're exempt or non-exempt. If they're non-exempt, we're paying them for that lunch break and deciding whether we're going to let them do that or be disciplined. If they're exempt, we can work them to death if we want to. Not saying that's a good plan, but it's up to us. All right, let me keep going. Let me go back here, see if I missed anything, because I've been scrolling through these questions to try to get the ones that probably apply to the most folks here. Give me 1 second, folks. I think maybe I have gotten all the questions. Okay, so somebody's asking about a K-12 school, and it's not, okay, I think they're saying there's a bunch of anonymous attendees asking questions, so I'm not sure if I'm connecting these two questions together correctly or not. They're saying they're a PA district. So the first thing that I would look at is for counselors and other professionals such as social workers, whether they're covered by a union contract, because almost all K through 12 public schools have teachers contracts, para contracts, and what I'll call associated professionals contracts as well. If you have somebody like a principal or superintendent, assistant principal, they're all probably going to be exempt because they're making independent decisions, independent judgment. But the first thing I would look at for counselors and social workers is to see what the contract calls for in terms of salary. And this is an important point for anybody who has a union. it's very unlikely that you have exempt union folks in the first place. It takes a rare institution like a K through 12 school where you might have that. But if you do have exempt union folks, this could be a subject of mandatory bargaining and you'd have to talk about it. So for the social workers and the counselors at your school, I'd look first and foremost to see if you have a union contract that covers them and go from there. Okay, let me look down here. I think I have covered all the questions. I thank you everybody for your time. I hope I've answered most of the questions at this point. If anybody else has anything, please feel free to put it up here now. And otherwise, I'm sorry we missed the disparate impact discussion, but hopefully this was more fruitful for everybody. I would say take care and enjoy the weather, but it doesn't look very good out there. Okay, great. I'm so glad I answered everything. You all are welcome who are saying thank you. You're quite welcome. I really enjoy this, and hopefully we've provided some good information. For those of you who had questions about the duties test, I'd really encourage you to go look at the webinar that we did on the FLSA and exemptions. It was a few months ago. We went over the duties tests in depth there and gave some case law examples of what would or wouldn't qualify as it. And that may provide you with some guidance as to what you need to do. Okay, great. Let me just make sure there's no more questions. Oh, great. Oh, everybody's quite welcome. Take care, everyone. We'll see you next month.